Good evening, Mr. Ronason.
No, you've got Mr. Renassen's next.
Oh, this is Mullins.
Yeah.
Okay. Well, my staff opened a wrong candidate. Yeah. Okay. They must have.
In any event, good evening.
Well, you don't want to go under somebody else's name because you never know what was going to befall you. So, good evening, Mr. Mullins.
Good evening, HSP.
Have we got everybody? Okay. Yeah. Okay, just get them back. Welcome to this session, Mr. Mullins, of the interviews of the Commission. Thank you very much for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court.
Thank you, ACG.
Yeah.
ACJ, I beg your pardon.
Thank you. I see from the questionnaire that you hold a BA and an LLB. Is that right?
That is correct.
And both degrees were obtained from Rhodes University.
Correct.
You got the BA in 1978 and the LLB in 1980.
That's correct, yes.
And you started your legal career as a prosecutor, is that right?
That is correct, yes.
And later on you became a state advocate.
Yes, in Durban. Yes.
In Durban. Yes. And then in 1988, you began your practice as an advocate at the bar.
Yes, July 1988.
July 1988. And you have continued to practice as an advocate without interruption up to today.
That's so. That is so, yes.
Yes. And that makes it about how many years of practice?
34 years, if I'm not mistaken.
Yes. Would you share with the commissioners the kind of types of cases that you have handled in your practice over the past 34 years in terms of different branches of law?
Well, initially, it was 1988. There was as was the custom in those days, you either did pro deos or, as a young advocate, a lot of the defending of in political matters. I did for a number of years. I did criminal work defending a variety of political criminal cases. I was briefed primarily by a firm known as Boy Majidina. I don't know if anybody knew him, who's in fact who's now Justice Mshlanshla. She was my main source of work in those days. But that work started fading away. It was all sponsored work from overseas, and it dried up as time went on, and criminal law was not really my bent, quite frankly. And I slowly got into civil work, mostly motion court work and trial work. Started off by and large in the magistrates' court, and then slowly but surely developed into the High Court. I have Port Elizabeth is not the sort of place where one can specialize very easily. So I have a wide variety of work. I have done very little criminal work in the last few years, and I must say, virtually throughout my career, virtually no labor work. I've done about 3 labor cases in my career, 3 or 4 if I'm not mistaken, and ironically won all of them. But it's something, labor law is something you've got to specialize in. You either do it or you don't, in my experience. Different rules apply, and it's in a different court. So I have done very little labor work.
Yes.
You could say virtually I haven't done any.
Was part of your practice commercial law work?
Yes.
A lot of it?
In recent years, yes.
Yes.
It's increasing, yes.
Yes. And I see that on the questionnaire, you said about 35% of your litigation work fell under administrative law.
Yes, that is again in recent years. A lot of work is there's review of tenders, that sort of type of work.
Yeah.
Work for and against municipalities.
Yes.
It's a growth industry.
Yes. Well, you do say about 10% would be family law,
Yes.
10% medical negligence cases, 10% personal injury, and 15% unlawful arrest and detentions.
Yeah. Yes. Those are rough percentages.
Yeah.
It depends on at the time.
Yeah.
You know, as life at the bar, work comes and goes. Sometimes it goes and doesn't come back for a while.
Yes, yes. And obviously you would have acted on the bench on many occasions during your practice.
On 4 occasions, which on page 28 you will see the acting appointments which I've enjoyed. Yes.
Yes. And there would be also many cases that you argued which are reported.
Some.
Yeah.
Unfortunately, a number of cases that I was involved in, I fell out of somewhere along the way for some or other reason that were reported, but I started. One of them was, for example, Mocha versus Butters, which went to the SCA eventually and was an important judgment in the field of universal partnerships. And unfortunately, I had to fall out of that matter, but I was the one who started it and took it as far as the SCA. But yes.
Okay, Judge President.
Thank you very much, ACJ. Good evening, Advocate Mullins.
Evening, JP.
You will recall that when I initially approached you for an acting stint, I had invited, I would say, male silks. One of the things that I shared was the importance of transformation. You will remember that occasion in my chambers in Port Elizabeth. You will also recall that one of the things that I highlighted was the fact that you should regularly have a baby junior, even in an instance where you have not been briefed together with a junior. You will remember that.
Yes, I do, JP.
Yes. Did you give heed to that?
I try to, JP. You must understand that it very often it's just not practical. One of the problems that we have in Port Elizabeth and particularly in Grahamstown is that there are not very many young, particularly female black juniors, and the difficulty is that because of briefing patterns that have nowadays, they're either too busy or you've got them doing acting appointments.
Thank you. Is there any scope for...
sorry,
you wanted to add?
No, it's fine.
Oh, all right. Is there any scope for applying case flow management in the context of appeals and criminal cases?
You know, I have had very little to do with case flow management, being a silk. It's dealt with nowadays in chambers by the Deputy Judge President in Port Elizabeth. My understanding is that it works exceptionally well. The feedback that I get from practitioners is that they're very happy with the way it works. Cases get onto the roll much faster. Cases that shouldn't be there are removed from the roll, and things are working swimmingly. As far as appeals, you say appeals and...
I said appeals and criminal cases or criminal trials.
Criminal trials seem to be, and as I don't do criminal work, but from what I hear, the talk in the corridors, getting criminal trials going and finalizing them seems to be an extremely problematical issue. How one gets the judge, the prosecution, the defense, and the accused all available at the same time, especially with COVID issues, seems to be a major problem, and I'm sure it's not only confined to Port Elizabeth. I think it's everywhere. So, how case flow management would work insofar as criminal cases are concerned, I'm actually at a loss to help you. So far as appeals are concerned, there would seem to be scope for improvement there, because what happens is a unhappy litigant files a notice of application for leave to appeal, and the procedure is that the parties are supposed to then approach the judge in question and arrange a date. And very often the matter just seems to drag on, and the successful litigant, the unsuccessful litigant, the last thing it wants to do is approach the judge. So those matters seem to drag on. I would think that case flow management in appeals would probably improve the situation and hurry the appeal along, because unfortunately these things take up to a year to be heard, and it's the old story of justice delayed is justice denied. Yes.
Yes. Well, maybe for the sake of completeness, I should mention that there is statutory basis for implementing case flow management beyond civil trials, and that
Yes.
is Rule 37, capital letter A. You remember that?
Yes.
It came into operation on 1 July 2019.
Yes.
Yes. Thank you very much, CJ. Oh, sorry, just one last aspect.
Okay.
On the issue of implementing case flow management in criminal trials, I invite you after this interview to read the Daily Dispatch newspaper, Monday's article dealing with case flow management in the context of a criminal trial. You will see there that Judge Dokota was allocated that matter to manage. A particular matter is referred to there. It's got to do with the Mandela Funeral Fund.
Yes.
If you read the Daily Dispatch, Monday's issue, you will see something is said there in the context of a criminal case.
Yes.
No further questions. Thank you.
As I said, I'm really not the right person to ask when it comes to criminal matters.
Yes. Thank you. I appreciate that. Thank you, ACJ.
And thank you, Judge President. MEC Gade, if you have questions for the candidate, I now give you a chance to put questions to him.
No, thanks, CJ. I don't have a question for the candidate.
Thank you. Commissioner Majesi.
It's just one question.
Yes.
No, when the JP asked you about briefings and Baby Junior, you don't want to tell him that in the matters that I gave you, there were Baby Juniors and all that. You don't want to speak about that.
Yes. Thank you for bringing that to my attention, Mr. Norchesi. I'm currently involved in a lengthy trial in Mthatha, where Mr. Norchesi is the briefing attorney, in which a baby junior, Odwa Makewani, is my junior. She keeps saying to me over and over that she can't believe how much she's learning, and she's so grateful that she's involved in this matter. But quite frankly, I think I'm the lucky one, because she's extremely helpful, and I think it's one of those situations where it's a win-win situation. I might also add that JP, I was briefed about a year ago in a matter by the state attorney in a case which I think has raised its head here in one of the previous interviews, the SPCA case, and Al-Mawashi. I'm briefed there for the various government departments. I pulled in a black male junior, and as a result of that, the state attorney concerned got to know of his existence, and he's now her advocate of choice in all junior matters. And so he's done well there. I also am involved in a matter against Eskom, and where I've briefed, which involves the Dr. Beyers Nordia municipality, where Eskom is suing the municipality for over 200 million. Eskom says it's 200 million. We say it's a lot less, obviously. But there I have a young black-white female, I beg your pardon, a young white female junior, who also, as a result of that, has had a lot of spin-off work. So thanks to Mr. Norchesi, he's jogged my memory. Now, those are 3 current matters. Yes.
Thank you. Commissioners on the virtual platform, is there anyone who has a question?
Yes. Yes, Professor.
Is there someone on the
No,
virtual?
thank you, JP.
Oh, thank you. Thank you. Thank you. Commissioner Schlemmer?
Thank you, ACJ. Good evening, sir. I just, for interest's sake, checked the law report when you said that you think there are some reported judgments, and I could find about 9 dating back to 2004, just for interest's sake.
Thank you for that.
Thank you.
SJ.
You would like to?
Yes, this morning I learned a new term for baby junior, devils.
Devils.
Yeah.
Yes.
That's another term for
Yes.
baby
Well,
juniors.
a devil is where a junior does research for you. It's called deviling. It's got nothing to do with Devil's Dorp or anything like that.
Thank you so much.
Commissioner Mpofu?
Yes.
Thank you. Good evening, Mr. Mullins.
Good evening, Mr.
Yes. No, I just wanted to question you about one issue which might arise when we do our deliberations, which is your age.
Yes.
As matters look, your age is against you. You are 65 at the moment.
Correct.
Yes. So, how can you convince us that we should overlook or not put too much weight on that factor, vis-a-vis because you can't change your age,
No.
but you might be bringing something else that might counterbalance that factor so that it doesn't count against you in the deliberations.
Yes, thank you. The one thing I think that money can't buy, and that's experience. And I believe that I have sufficient experience to walk straight into the job without trying to blow my own trumpet. If one has a reference to the judgments that I delivered during during my 4 acting stints, I think they speak for themselves.
Yes, I'm particularly impressed by your judgment on delinquency.
Which one was that, Advocate?
It's the one, it's a long one. It's Nicholas Petrus Blake
Blake, yes.
versus
Yes.
Dry.
Yes, that was a clear case of fronting where the parties had fallen out and they tried to get rid of their black partner. And anyway, I wasn't going to have any of it. Yes. Earlier in the week, I know the acting Chief Justice mentioned just one of the candidates that why should an older candidate be appointed and then get the benefits of a pension?
Yes.
That's where somebody's been on the bench for 15, 20 years gets the same pension. My understanding of my understanding of the Judges Remuneration Act is that you've got to have served for 15 years before you qualify for a full pension. Otherwise, you only qualify for a portion, or whatever the
Prorated. Amount.
pro rata. Yes, so that isn't a difficulty. But that's the long answer to your question. The short answer is I believe that I have the experience.
Well, of course, what remains would be that society would get benefits by way of the services of a younger but experienced judge over a long period of time before they get the pension benefits. Whereas when you come to the bench very late, there is a limit up to when the number of years you can be allowed
Yes.
to serve
Yes.
is limited, you know. So there would still be that situation.
The retirement age is mandatory
Yeah.
at 75.
Yes, yeah.
Yeah. Insofar as my age is concerned, Advocate Mpofu, I'm fit and healthy as far as I'm aware, and so there's no difficulty on that score.
Thank you. So all things being equal, you would still have 10 years to offer.
Yes. If I do not succeed in being elevated to the bench, I intend to carry on working indefinitely anyway.
Thank you very much.
Okay. It looks like there is no question. There are no questions anymore. We have come to the end of this interview. Thank you very much, Mr. Mullins. We appreciate
Thank
that
you.
you
Thank you,
made
Chief
yourself
Justice.
available. You are now excused.
Thank you, Chief Justice.
Thank you.